Welcome, everyone, to the Beyond the Algorithm Reading Club. I'm Catherine Steeves. I'm the Program Director for the AI and Machine Learning Initiative of the Ontario Council of University Libraries. It's my pleasure to welcome our guest today, Professor Karis Craig. She's an award-winning teacher and researcher with the Osgood Hall Law School at York University. She's the academic director of the Osgood Professional Development LLM program in intellectual property law and director of IP Osgood. Dr. Craig teaches and publishes in the areas of copyright, trademarks, law and technology, and legal theory, with an emphasis on authorship, user rights, and the public domain. And today, we are here to discuss her recent publication in the Chicago-Kent Law Review entitled The AI Copyright Trap. Welcome, Karis.
Thank you so much, Catherine. It's lovely to be here with you. I'm looking forward to the conversation.
Excellent. So first of all, thank you for publishing this article. The argument you make against mistaking copyright law as the best tool to support creators and culture in the AI age is incredibly important. So too is the urgent call you make to bring user rights into the dialogue. So let's get started. So our first question is, what inspired you to write this article?
Yeah, it's a good place to start. I think I was getting most of my articles start this way, just increasingly frustrated with listening to people talk about things and feeling that there was something that was going unsaid. There was that, and then there was also just the sense that the people I would normally completely agree with on almost everything. And the people who were out there fighting for the public interest and for justice and fairness and equality were talking about copyright law in a way that just struck me as sort of inconsistent or discordant with what needed to be done. So I realized at that point that my views on copyright law and AI training and the role of copyright in the sort of new cultural landscape where we're seeing generative AI sort of proliferate, that my sense of what copyright law should be doing and should not be doing was increasingly at odds with the people whose politics I agreed with. And so I saw there that there was some sort of disconnect in the conversation or some sort of misstep that I wanted to correct. And I was invited by Ed Lee, who was putting together the symposium in the Chicago-Kent Law Review, just to contribute an essay that was sort of discursive and provocative. It didn't need to be heavily footnoted. It just was a sort of intervention in the debate. And I
Mhm.
thought, well, that's perfect for me to get this off my chest.
Excellent. All right, let's move on to the next question. All right, so for those who may not have had time to read the article, can you briefly describe what the AI copyright trap is?
Um, I can, I think. I hope. I was just saying I haven't reread it for a little while, and so it's such a rapidly changing landscape that it keeps changing sort of underneath our feet. But I think the copyright trap itself that I'm referring to is still very much in place, and I keep seeing people run into it. So let me try and explain what I meant by calling it a trap. Um, there are a lot of very valid, very important concerns being expressed right now about the impact of generative AI on our cultural landscape, on our creators, on the quality of our cultural discourse. And so there are lots of real concerns about generative AI that copyright law is not well placed to solve. And the trap is assuming that when we turn to copyright law, we're going to find a sort of regulatory tool that will help us sort of reintroduce fairness into the cultural landscape, that will protect our creators, that will ensure that our culture continues to thrive, that will hold back the threat that generative AI presents. And it's a trap in the sense that, first of all, as I argue in the paper, I think copyright can do more harm than good here. I think that expanded copyright control is possibly the exact wrong thing to do if what we care about is the health of our cultural environment and our creative enterprises. Like I think that the more that we turn to copyright and expanding copyright and ensuring that it controls the training of AI, the more sure it becomes that we are going to create an environment where we have huge corporate entities owning and controlling the future of human creativity
Mhm.
and our culture.
Yeah.
And it sounds to me like that's what people want to avoid, that we want to protect the public domain, we want to protect the cultural commons, we want to protect um, sort of lively, creative conversation.
Mhm.
And copyright law is actually a tool of commodification, of control, of exploitation, of exclusivity and exclusion that is going to underscore and augment the harms that generative AI threatens, rather than empowering creators or reining in the excesses of generative AI.
Yeah. So, hearing you explain that, and after reading your article, this paradox of advocating for expanded copyright control for AI as a means to save the knowledge commons from corporate enclosure, it seems obvious. What forces do you think are causing this to be overlooked or seen as controversial by copyright commentators and AI critics?
So I think, and this is something that I suppose is implied by calling it a trap. It kind of suggests that it is being laid for us, and
Mhm.
that there are parties who stand to benefit from enticing us
Right.
into the sort of copyright turn when it comes to regulating AI. And so I think that those are just the usual corporate forces. I think big tech has a huge interest actually in the sort of proprietary logics of copyright, because they're best placed to hire the lawyers, absorb the transaction costs and
Mhm.
pay for the licensing of giant data sets that will allow them to essentially monopolize the landscape. So I think that there are large sort of tech industry actors who are perfectly happy to work through the established systems of copyright that they can ably control with the means that they have available to
Yeah.
them. And then I think, the entertainment industry, the publishing industry, and so on, like they sense a kind of windfall if they have a whole new product or data set that they can extract license fees for.
Mhm.
And so perhaps they stand to gain. I think the copyright collectives, I think I said before, kind of smell blood in the water. Like I think there's a sense that
Yeah.
there's again money to be brought in and maybe dispersed. So I think there are big actors who stand to gain economically from just sort of doubling down on copyright law and engaging in their private market transactions, paying license fees, securing more fees, and enjoying the windfall benefits of this new technology. Um, and so all of those parties are quite happy around the table talking about, well, how do we structure the sort of the licensing arrangements or the tariffs or that we're obviously going to turn to as a solution. Um, the I've just never really believed in the trickle down kind of assumptions that if the large sort of corporate intermediaries benefit, then artists and authors and actors and performers and musicians and others are all going to ultimately reap the benefits
Mhm.
of those private arrangements. I think we're already seeing that that's not going to be the case.
Mhm.
But in terms of like maybe more conceptually, so that's kind of the sort of political economy of it.
Yeah.
More conceptually, I would say, and I do identify in the article, there are some sort of some tropes and some sort of common sort of myths or copyright narratives that are leading people into the copyright trap. And
Hmm.
these are not new. These have been part of the copyright discourse and the cultural landscape for um, decades and indeed centuries, but they have a new salience that hasn't really been acknowledged. So
Hmm.
that's what I try to do in the paper. I say, the assumption that everything that is valuable should be turned into a private property right. That's a fallacy. The if value then right fallacy is leading and informing a lot of the debate that we're hearing around generative AI right now.
Yeah.
And that means that, the assumption that because some value is being gained or extracted, that means that private property is the answer to that, that we have to allow someone to sort of capture that and occupy it and exclude others from it, that's not that's first of all not accurate, but also it tends to lead to a sort of commoditized culture that we probably want to resist.
Hmm.
The other route in, if value then right is one, the other is the sort of morals around copying and the sort of obsession that we have with the idea that, well, if something's a copy, then it must be that it's either authorized or permitted or it's unlawful and it's wrong. And there's a sort of moralism around the idea that copying is wrong,
Hmm.
and copying requires permission. And if that's our sort of default assumption, then we know that copies have to be made in order to create data and training sets for training AI. And so copyright comes in right at the start and just says, oh, actually, by the way, this is all unlawful unless you have permission from every copyright owner for every original expression that's found its way into this data set of billions of cultural artifacts that are all within it. Like every single person with a right in any of these works or all of these rights must have agreed.
Right.
And
It's
before
just
you
not
can do
feasible, even if it were,
even if it
logical.
were right, it would be wrong, right? Like it's not feasible. It's as impossible
Yeah,
as it is kind of pointless to insist upon it, I think.
that's right.
So I sort of try to argue our obsession with just individual copies and whether a technical copy was made somewhere digitally in the background of something is kind of an anachronism
Mm.
that we've managed to work with in the digital age. Okay, a digital copy is a copy, but we need to start thinking more about the way the work sort of moves, the way it's being used in the system, and less about the technicality of whether copies are rendered. And we shouldn't assume from the beginning that copying is wrong and requires permission. There are lots of
Mm-hmm.
permitted copying practices upon which we rely, and that the copyright system leaves plenty of room for.
Hmm.
And we need to remember what those are, right? First of all, the fact that information and data is public domain, that you don't need permission to copy information, to copy data, it's not owned. And also like fair dealing for the purpose of research, of course, is another example of that.
Yeah,
And so, we just shouldn't begin with the assumption that because there's copying,
yeah.
there's been some.
So there's the if value, then right, fallacy or trap.
Mhm.
There's the all copying is wrong, fallacy or trap. Is there another?
The last one, the third one I point to, which might get me into the most trouble, is the copyright is there to help starving or struggling artists.
Uh,
Yeah, so pulling out the sort of struggling artist as the final trope, as this sort of political, this sympathetic figure that is so often trotted out to justify the expansion of copyright controls that actually go down to the benefit of corporate owners or corporate interests, and rarely, in fact, to the
Mhm.
artists or the authors that we're hoping to protect or to encourage. And so this is the piece where I say, okay, I don't see how any of the solutions that are being proposed for sort of expanded copyright control to limit generative AI. I don't see how any of the solutions are actually going to help
Yeah, or benefit the
artists
creator
and
directly.
authors and the
Yeah.
creators that they are being justified in respect of.
Hmm.
And the reason in part is that is the scale problem, right? The idea that we have, billions of of text on which these systems are being trained. I think lay people who are not particularly familiar with copyright law might just assume that copyright attaches to, the final Hollywood movie or the Margaret Atwood novel. Like these are the things that we recognize as the works, and these are the artists that we want to protect. But the reality, of course, is that copyright attaches to everything, and
Mhm.
everybody is an author and everybody is a user, and we're all in this. And so the idea, first of all, that we can sort of separate out the sort of professional authors and professional artists as a sort of professional creative class, and then design around their economic and professional interests
Mhm.
a law and a system that regulates everybody's behavior, all of the like the trajectory of the technology in its entirety to
Mhm.
ensure that a small category of artists and authors who earn their livelihoods through their creativity is protected. First of all, that to me seems risky, right? There's so much more going on than just our concern about the livelihoods of a group of professional creators.
Yeah.
And if we are worried about the livelihoods and economic success of a group of professional creators, there are far better ways to ensure that they can practice their craft and engage in this and earn a living wage than relying upon sort of micro payments through licensing schemes with huge transaction costs
Mhm.
in the context of systems that are trained on billions of examples of works gathered from around the world.
Yeah,
So,
and
it's just a sort of like be aware that copyright hasn't always served the interests of the struggling artist anyway,
yeah.
and don't fall for the sort of the political discourse that would suggest that that's a good basis on which to expand copyright
Well,
control
I
here.
think in your article in this section, you do a really good job too of even if it was a question that the legal system could help with or assist, that there are many other areas of law that might be more beneficial to the creators in terms of trying to protect their livelihood or their craft. So this is a good segue to the next question that I had. So I found that your discussion of Timnit Gebru's recent work, AI art and its impact on artists, was very engaging. Can you say a little bit more about AI ethics in relation to creators or authors and how power might interact with technology and copyright in this area?
Yeah, thank you. I mean, this is the example I think of. I wanted to make sure that in the paper I wasn't like picking straw men that I could easily shoot
Yeah,
down, right? Like
yeah,
I really wanted to pick the best, most insightful, most persuasive commentators in the area and address the concerns that they were raising at the same time as saying like this is not the right turn, this is the copyright trap.
yeah,
And so Timnit Gebru is the sort of perfect example of that, in the sense that her um in general her push for the need for ethical AI that and the recognition of the sort of inequalities, the biases that it can produce, the sort of extractive logics on which it depends, the sort of complete disregard of the public interests and the people who are likely to suffer most the consequences of it. That's all so pertinent and so
mhm,
well put in her work. And then my concern is that suddenly one of the ethical problems that's identified amongst all of the others is, the extraction of works of human authorship and their use. And then the solution that is sort of gestured towards then is like, copyright law prevents that. We need to respect copyright law, and that therefore would be a more ethical AI environment, one where artists and authors had control over whether their works were used to train AI systems. And it's so compelling. She also, when it comes to talking about credit and consent and compensation, a lot of the commentators are using these sort of three C's to say that's what creators and authors deserve. So put aside your arguments about fair use or fair dealing, or information deserves to be free, and instead like think about consent and credit and compensation for the human creators. So I think it all sounds so compelling on its face that I wanted to think a little bit more critically about, well, what does credit look like here? And the idea that everybody whose work um, was included in a massive database on which a massive AI system was trained, and that everybody all of those authors, and it's complicated in copyright law, right? Because
Yeah.
it's actually the owners that would be getting it, but it's the
Yeah.
authors whose credit we're worried about. So already there's a mismatch. And then the idea that what you would be like just a name included in a database of billions of names, and then no one knows exactly to what extent your contribution was the thing that informed the
Yeah.
output that probably has very little value. I just didn't understand it. I just don't find that a compelling answer. But Tim Nick Gabru said in her piece, I think, something like, well, we never get to do that in any other context to say, well, that's too complicated. There's too many things involved. So we're not going to tell you the ingredients in this product that we're selling, or we're not going to. And I take that point, but we don't get ingredient lists so that we insist that every brand of every ingredient and every final product is acknowledged. The reason we have ingredient lists is because there's a public interest served by knowing what's in the mix. And I can imagine there might be contexts where there really is a public interest served by knowing what's in the mix, depending upon what the AI model is doing and the size and scope of the training data and the implications of it. But I think as a general rule, especially for something the size of ChatGPT, that we would have, and we all need some sort of acknowledgement or credit for our contributions. I just think it misses the point. It misses the harms, like I think we should be looking at, well, where are the harms? And that to me, just the fact that your work or something you once wrote is one of a billion things on which AI is trained, that's not the harm. The harm is what happens when the outputs are undermining our sort of cultural ecosystem, or polluting our cultural ecosystem might be a better way to put it. The harm is a lack of knowledge or transparency about what it is that we're getting. The harm is that we're allowing for human culture to be substituted in a way that is ultimately risking the sort of health of arts and culture. I mean, these are real harms, but
Hmm.
having a database of billions of names to give you credit to the fact that your work was in the training data seems to me besides the point.
Okay. So you've started along the my next track in just talking about some of the potential harms, but I was wondering how you might define ethical and responsible AI and sort of thinking beyond intellectual property or copyright. What regulation do you think is essential to advancing AI for the public good and humanity?
Well, that's a
It's
big
huge.
question, and it's
Yeah,
a huge question, and I'm very tempted to say like it's kind of outside my.
that's
Well,
fine
at
if
the end of the
that's
day, I'm a copyright law professor,
yeah.
and so what I would say is that I am very concerned. With I'm very concerned with equality and bias. I'm very concerned with inclusion. And all of my work in the copyright field is really pushing towards um, creating the conditions for a participatory culture that is inclusive. And so that means there's a role for copyright in empowering and encouraging people to engage in that cultural conversation, to create, to express themselves. But copyright is just a means really to that end. It's a tool in a cultural policy that ensures this kind of room for expressive agency and creativity and participation. And so my concern, like when I'm framing it in that way, I think we really need to have our eye on, first of all, the issues that have been raised by others on the biases that are exacerbated
Mhm.
by AI tools.
Yeah.
And that in a way is related to, the data that goes into them, right? The garbage in, garbage out
Mhm.
concern, right? So quality data that is in a way sort of curated to minimize those sort of natural tendencies to exacerbate biases that the technology has. Like, I think we should have our eye on that, right? So
Mhm.
in that
Mhm.
kind of regard, I'm concerned about the quality of the data that is available for training. I also, when I'm talking about inclusivity, I worry that our increasing reliance upon these tools means that we need to have tools that produce outputs that are inclusive and reflective of sort of diversity and the heterogeneity of our culture. We don't want to have something that just goes straight down the middle and reinforces sort of dominant cultural strands. And again, that makes me say the data needs to be inclusive. We have to be more concerned about what it includes and the quality of what's included than making sure it's exclusive.
Yes.
And I actually worry that the more exclusivity we insist upon through copyright control, um, the more those harms become real, right? Because you
Yes.
end up with this sort of monopolistic context where you have limited data sets that are from the sort of dominant market actors, from the dominant cultures. That's what gets in, and then that's what gets used. And meanwhile, smaller players can't afford to access quality data. There are huge gaps in their data sets and a lack of transparency because of fears of the unlawfulness of the data training processes. And then you end up with just not a healthy
Mm.
ecosystem or information system within which these very powerful tools are being trained and deployed and kind of let loose. So I think that all suggests that that's why we need to turn away from copyright and exclusive control and proprietary systems that will ultimately depend upon the sort of money and power, and
Mhm.
think more about how do we want to ensure that we have good quality data, that an inclusive and competitive landscape for the
Mhm.
development of quality tools that do not exclude, that do not exacerbate bias, and that don't just serve large corporate interests. So
Yeah.
maybe an eye on sort of public development of data sets, open source, open access data, um, and tools which many people can use for their own particular goals rather than closed proprietary systems where we're dependent upon a couple of corporate actors and their profit
Mhm. So we're
motivation.
almost through the interview, just a couple of more questions. And I thought maybe we could bring it back down to Canadian copyright activity and legislation. And one of the things you highlight in talking about this shift in the dialogue around artificial intelligence and copyright was between 2019, the consultation on the Copyright Act and AI, in 2023. And in 2023, the copyright in the age of generative AI consultation really came to favor author and creative industry rights and neglected the public side of the copyright balance when it was more balanced in 2019. So I would just like to invite you to talk a little bit about what's happening in Canada right now in relation to this legislation and any attempt to balance this for user rights.
Yeah. Yeah, thank you for this. And actually, it's another piece of sort of the original motivation for writing this, because I could see as well this sort of shift happening in the way that sort of policymakers and government actors were talking about copyright and AI once ChatGPT was released, and I think people began to see the
Mhm.
power and the sort of future pervasiveness of this system and the quality of the sort of political discourse around it began to concern me. And so to go more specifically into sort of the lawmaking part of this, back when we did the 2019 Copyright Act review, there was, not that many people around the table who came in and were invited to talk about AI. Like that
Right.
was kind of a pretty
Yeah.
much a sort of side note. And certainly, I mean, I testified during that Copyright Act review, and I didn't mention AI.
Yeah.
A few people did. Some people had their eye on it, but I think what came out of that review was the government's willingness really to consider adding an exception that was for informational analysis,
Right.
because they were persuaded really that the process of compiling data in order to analyze it, to detect patterns,
Mhm.
probabilities, to extract data, like that was going to be the sort of vital to the future of an innovative Canada, right? Where
Right.
there was openness to new technologies, and that was really the sort of the impulse behind a lot of government policy making was we want to be hospitable to innovators. This is the next big thing. We want Canada to be in there. And so, of course, we just need to just enact this like tiny little exception for, informational analysis, and we can all move on with our lives.
Yeah.
And it would have been nice if we had done that, frankly, because then it would have been there, and we would have had some sort of, I don't know, comfort in the idea that some of the training of AI models in Canada is lawful.
Mhm.
Instead, what we're relying upon now is the idea of fair dealing for research, maybe arguably for education, but these arguments have really yet to be fully tested, and so it's created a really uncertain landscape for AI training in Canada right now.
Mhm.
I think, in answer to your question of like what shifted, in part, it's been suggested to me that we've just become, as a nation, a little bit less optimistic about our leading role in the development of the technology. And then I think also as well, we've seen a lot more sort of, I was going to say rabble rousing, maybe that's too pejorative, but we've seen a lot more vocal interventions in the policy discussions by the usual powers that be in the Canadian
Yeah.
policy landscape, of which librarians are very aware, but the copyright collectives, the publishers, the cultural industry actors are much more sort of prevalent in the copyright discourse, saying to the government,
Mhm.
no, we want our piece of the pie here. This is unlawful. This is copyright infringement. You need to make that clear.
Mhm.
And so that changed the nature of the debate. And I think what has happened now is that the most recent consultations have very much positioned themselves as, looking more to developments in Europe, a little bit unsure of how things are going to go. So there's a lot of stalling, perhaps, between the European and the US models, as usual in Canada.
Mhm.
But there's also increasingly a sense that like just a broad exception for text and data mining is probably off the table. Like the moment for that has probably passed.
Mhm.
And instead, the way that the policy debate is being framed is between technology industry actors like big tech
Yeah.
and our cultural industries and the need to support our cultural industries. And that's the balance. And the thing
Right.
I tried to point out in the paper and the thing that's concerning me is that the copyright balance was always sort of owners on one side and users on the other,
Yeah.
like the authors and the public interest. And there was no mention of that balance. The balance
Mhm.
has become one of two different industries whose
Mhm.
interests are being balanced off against one another.
Yeah.
And to my mind, the public interest and the rights of users have just disappeared from view. And meanwhile, the rights of users and fair dealing have been kind of tainted by this to the extent that we don't like this activity by big tech. It's harder to talk about broad and expansive fair dealing rights without
Mhm.
running into this copyright trap again.
So who do you think, like, who should be a part of this coalition to argue for the public good and user rights and to try and get that third leg of the stool, or maybe back to a balance of two, um, uh, beyond the librarians? Like, who are our coalition
Oh,
partners?
we're counting
Should
on the librarians. It's got to
civil
be you.
society should be partnering with civil society, with lawyers like you. Who, how can we raise our voices and who needs to
I
be a
mean,
part of that?
I feel that in Canada we had a really strong sort of coalition of public interest actors in the educational environment, in libraries, information sciences, who were, and in technology, to be honest, as well, who were really sort of committed to the idea that user rights were vital to good copyright policy, that there has to be an appropriate balance, that the public domain must be preserved. We've got like 20 years at this point of wonderful Supreme Court jurisprudence underscoring this fact. We've had at least a decade, I think, of sort of government policy makers just taking the copyright balance as the sort of, foundation on which good copyright policy is built. And for some reason, I think the sort of, I don't just want to call it a moral panic, but there's a piece of that, but our panic around the sort of the rapid arrival of generative AI and the potential harms
Yeah.
that it brings with it has caused us to kind of forfeit that. And
Yeah.
even the people who were committed to Creative Commons, who were committed to open access, who were committed to fair dealing for educational institutions, fair dealing for research, so many of them are beginning to lose confidence in that stance
Yeah.
because they don't like big tech and they don't like generative AI. And so I just really think we need to refocus. Let's not destroy what we worked for.
Mhm.
Let's not destroy the balance that we're able to build in a knee-jerk response to this technology. Like that's exactly the wrong thing to do. And
Mhm.
I can see how right now we're playing into the hands of those who would like us to do that. We just need a corrective. And then we
Mhm.
need to think, okay, what does good balanced copyright policy look like in response to this technology or in this technological era? We need to constantly be engaging in that sort of finding that equilibrium between protection and access, between ownership and the public domain. And this is no exception. So
Right.
we have to just not lose sight of that.
Well, thank you very much. I think that's probably a good place to end. I know, uh, I've learned a lot from this conversation, from your article. It's so amazing that you are raising this alarm because I do think it's really important. I think we've lost some ground in the work we've done to promote open access in scholarly communication, in that now many of our scholars are concerned, as you were saying, about corporate ownership and the commercialization of their knowledge, and we need to re-engage them around the positive value of open access to data and to knowledge, and really pay attention to this because things are moving pretty quickly. So thank you very much, Karis. I'm just going to go back to this, make sure I don't forget anything. So thank you very much for joining us today. Um, at the end of this video, we're going to provide some information so that the audience will be able to find a link to a site that will provide access to the article, as well as provide some information about some community discussions that are upcoming in January. There should be two scheduled. And Karis, we really hope that you can join us for one of those discussions. And we look forward to seeing, the broad member of the OCUL community and beyond to really dig in and discuss some of the important issues that you've raised today. So thank you very much for your time. Enjoy the rest of your day, and I hope we get a chance to connect again soon. I know we will in January, but perhaps beyond, we can continue this conversation and build that coalition.
Wonderful. Well, thank you again so much for the opportunity to talk to you about this. And I really look forward to hearing the discussion and hearing what people think about it. So it's
Okay.
certainly, a rapidly moving topic. And I know there are a lot of well-meaning voices out there and lots of different views about the best way forward. And, we're all just trying to come up with our answers for a very rapidly changing environment. So I look forward to those conversations, and I thank you in the meantime for your attention to this and for bearing with me.
All right. Thank you very much.
Cheers.
Bye bye.